And no more words, and I'll start immediately. So the aim of my paper today is to contextualize even further, after Bain's paper, the Treaty of Waitangi. And to do so, I will firstly look at the long historical tradition of treaty making between European and non-European polities to negotiate European expansion. I will then consider the ways in which the Treaty of Waitangi was or was not coherent with conventional practices of expansion in the 19th century British Empire. And thirdly, I will quickly assess the possible impact of the treaty, particularly in the neighboring Australian colonies. So European and non-European societies used warfare, trade, diplomacy, and treaty making to deal with each other. Though concluding treaties with non-Christians was contentious in the early modern period, Dutch colonial promoters, soon followed by other European states, adopted treaty making as the basis of their overseas expansion from the 1600s onwards. Those treaties were contractual agreements, binding agreements, and each side, sometimes Europeans, in other contexts non-European, used intimidation and violence to force compliance. In the early modern era, at a time where state formation was not completed, the ability to conclude treaties was not exclusive to the sovereign, even though states were making that claim. Treaties could be negotiated and signed by home governments, colonial administrators, chartered corporations, or even individuals acting on behalf of their ruler or on their own. Europeans signed treaties that were public, formal, and written agreements between sovereigns. They also signed treaties that were private agreements between individuals that would and sometimes would not be endorsed by their rulers. On both European and non-European sides, the issue of who was empowered to treat was critical. It encompassed the question of authority within one's group and one's representativeness of the group's interests. In the 19th century British Empire, the Crown claimed her exclusive right to make treaty with indigenous peoples and used that right in order to create and consolidate her imperial sovereignty. That claim was not as inflexible as it sounds, and the Crown supported at times private initiatives to conclude treaties in newly settled territories. On the non-European side, the issue of who was empowered to treat was also critical. In societies where power was strictly organized, delegates were generally endorsed by their ruler. In societies where power was shared more horizontally, things could get very tricky. Individuals could negotiate a treaty on their behalf or that of their group, but without being endorsed by their whole community. In North America, for example, conflicts arose within indigenous groups for this reason. Yet Europeans refused generally to take into account that fact and considered the whole community bound to comply with the treaty negotiated. Since for Europeans treaties were meant to support the expansion, treaties were very heterogeneous both in form and content. Treaties concluded in areas where contact, especially commercial contact, with local peoples had long been established, tended to be concerned with conquest and transfer of sovereignty. On the other hand, treaties signed in areas where the European presence was weak and dependent upon local assistance were generally more concerned with trade, military assistance, and transfer of property. The fact that treaty making was essential in supporting European expansion does not mean that it was exclusively promoted by Europeans or always detrimental to indigenous peoples. Historians have uncovered ample evidence that local rulers initiated contract agreements with Europeans in order to further their own interests, whether it was to support their rivalries with other local or European groups, strengthen their authority, extend their territory, obtain commercial rights, and so on. So from the mid-18th century onwards, Europeans greatly resorted to treaty making to negotiate their overseas expansion. They favored cession through treaty above all other possible titles such as conquest, discovery, and occupation, because cession was the least challengeable title in imperial politics. Cession could also be used in ways that were complementary with the other bases for title. For example, conquest followed by a treaty and occupation of sovereignty followed by treaties for property. Cession was perceived to be the strongest title because it was based on the doctrine of consent to which the Europeans were historically attached. The idea of consent had developed in reform movements such as medieval conciliarism and French Protestant resistance. 17th century English political theorists such as John Locke argued that consent only could legitimate authority. Though European philosophers disagreed on whether colonial expansion required indigenous consent, many 19th century international lawyers claim that it did, and they promoted treaties as the most legitimate way of expanding European empires and constructing political legitimacy. Obviously, Europeans pursued treaty making not because either philosophers or lawyers wished it, but because the reality of colonial power relations dictated the necessity of agreements. Philosophers and lawyers then provided a framework for those agreements. In the late 19th century, the Berlin Conference participants would push things further and establish treaty making as the normative process legitimating European expansion in international law. They would do so while acknowledging that European powers also manipulated the idea of consent to suit their purposes. In many contexts, the Europeans concluded fraudulent treaties, treaties whose terms were not explained to indigenous signatories, treaties with added clauses, treaties signed under pressure, and so on. In any case, whether consent was generally obtained or not, its appearance still mattered. So now I'm going to focus on the British Empire. So after they lost their North American colonies in 1783, the British established colonies in Western Africa, Madagascar, Malaysia, Northwestern America, and New Holland, or Botany Bay. Everywhere with the exception of Botany Bay, they negotiated their settlements through agreements of purchase or rent. Their property rights resulted from their purchase, real or fictive, of native lands, while they based their claim to sovereignty by right of discovery, conquest, occupation, or cession. In the mid-1830s, British philanthropic concerns about the worrying situation of indigenous peoples, particularly in South Africa and Australia, contributed to greater public awareness of the denial of indigenous rights. Observers started questioning the kind of titles the Crown claimed on overseas lands and made conflicting recommendations on the issue of treaty making. While a parliamentary committee in 1837 rejected treaties with indigenous peoples because they were detrimental to native interests, the Aborigines Protection Societies, which was founded the same year in 1937, recommended that indigenous property and sovereignty rights ought to be transferred by treaty. The society claimed that native peoples ought to be enabled, and I quote, to put themselves in a position of defending themselves and their rights, and they may be encouraged to form treaties of friendship, not only with the British government, but with one another for their own mutual defense and protection," unquote. Since it was believed dispossession could not be undone in Australia, it was critical that British expansion in the Pacific would take place on the right footing. Sachs Bannister, New South Wales' first Attorney General and a long-time advocate of Aboriginal rights, recommended organizing, and I quote him, "a Pacific coalition under British influence and mediation," a suggestion that was endorsed by the Aborigines Protection Society. To defend British economic interests in the South Seas and protect Maori people against settlers' mistreatments and invasions, the government authorized the colonization of New Zealand, and it also followed, as you all know, the Aboriginal Protection Society's advice to conclude a treaty with the Maori. So to account for the signature of the Treaty of Waitangi, especially in the context of a British refusal to enter into treaty making in Australia at the same time, historians have emphasized British reliance on anthropology and the progressive theory of history. It has been argued that Europeans assessed indigenous entitlements on the basis of cultural stereotypes, and they consequently accepted or dismissed treaty protocol accordingly. For the Treaty of Waitangi to be concluded, the Maori were to be included into the family of nations, which was made possible because the Colonial Office believed the Maori to be cultivators capable of rudimentary government. This explanation, which has become increasingly conventional, needs to be reconsidered. If we look at the British Empire in its globality, we find that the British signed treaties, for example, in Upper Canada, with nomadic societies, which they considered as having basic political structures, while they did not enter into such agreements with agricultural societies that had more complex political organizations. To account for that contrast, we need to take into consideration the balance of power in each context. As I said earlier, even though the British, like their European counterparts, favored expanding their empire by treaty, they did not feel constrained by this principle. The balance of power mattered too. The British acknowledged indigenous entitlements and signed treaties when they were in positions of weakness, and ignored those entitlements when they were in a stronger position and if this suited them. They used anthropology subsequently to validate their respect or disregard of indigenous entitlements. And once again, the Pacific context illustrates that trend. The British did not conclude a treaty in Eastern Australia because they first believed that they were unable to negotiate indigenous consent to their possession. The extent of so-called wastelands added to anthropological descriptions, stressing the brutishness and harmlessness of the supposedly scarce Aboriginals, justified the decision to disregard their claims and rationalized their exclusion from the family of nations. In New Zealand, on the other hand, the balance of power was favorable to the Maori. Descriptions emphasizing their agricultural and political activities would rank them on a higher point of the human ladder imagined by theorists of progressive history. They would consequently qualify them as partners capable of entering into a treaty protocol. Elsewhere in the Pacific, the British concluded several treaties of cession from the 1840s onwards. Waitangi was therefore consistent with both European and British imperial practices. Did the treaty have an impact on neighboring Australian colonies? Discursively, yes, even though that impact was momentary. Proponents of a treaty between Aboriginals and colonial governments tried to exploit the apparent inconsistency of the Colonial Office to defend Aboriginal claims. In 1841, the resident judge of Port Phillip, Justice John Willis, used the Treaty of Waitangi to question British title. He questioned British jurisdiction over Aboriginal peoples on the ground that no transfer of sovereignty had taken place, in contrast to New Zealand, where the Treaty of Waitangi had allegedly achieved that process. In Western Australia, the great majority of the settlers rejected the idea of concluding a treaty, despite earlier considerations to do so. Entering into a treaty would have resulted in the reassessment of their property titles, and they would have had to purchase the lands they had settled. To rule out any threat to the titles, the settlers argued that the Crown was responsible for buying the land she had distributed, a move which the home government did not support anyhow. So to conclude, I will say a few words on the historiographical perceptions of these colonial treaties. Historians have generally given little attention to colonial treaties for the reason that many treaties were fraudulent or signed under coercion. They have disagreed on the question of the legal inclusiveness of the European law of nations, that is, whether that system put non-European sovereigns on the same footing as their European counterparts. Those who claim that the European law of nations did not include non-European societies also argue that Europeans did not value treaties signed with non-Europeans. Historians have also pointed to the inequality of these treaties, that is, the often great disproportion in the benefits obtained. Fraud, intimidation, inequality, those were real aspects or components of a great number of treaties, but they were not exclusive to colonial treaties. Europeans also concluded with each other treaties that were marred by dishonesty, fraud, and intimidation. They also signed treaties that were so unequal that, according to the Swiss jurist Aimé de Vattel, they prejudiced the sovereignty of the inferior power. Another reason why historians do not take these treaties seriously concerns I'll just echo what Bain was saying earlier, concerns their epistemological inability to overcome what they know of dispossession as a historical process. Because they know that treaties would be used sooner or later to dispossess indigenous peoples, they become blind to the processes that shape these developments and to the moments when the outcome was still in question. They also become blind to the actors who negotiated these treaties and tend to simplify the dynamics of relations between indigenous and European peoples. It is important to look at these treaties contextually rather than dismissing them on the ground that they were mere legal fictions. I believe we must take these treaties seriously and not ignore or shy away from their complex and historical natures, because some of them still shape the lives of many indigenous and non-indigenous people around the world. And a meeting such as this one is a great illustration of that concern. Thank you.